Hey y'all, this is Immigration Live with me, Attorney Lillian, and today we are going to be talking all about the I-751 waivers. Okay, you have a 2-year green card and you are looking to file to remove the conditions, which is a requirement, right? But you and your spouse are either no longer together or you have actually gotten a divorce. Can you still remove your condition if that is the situation? And the answer to that is yes, but it depends. So that's what we're going to talk about today in this immigration chat. If this is your first time here, hi, welcome. I am Lillian Chukura. I am a U.S. immigration attorney and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. Okay. If you would like to schedule a consultation with me, you can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. And if you want to join my community of informed immigrants, please do that by hitting the subscribe button so that you know every time that I go live. Now, let's jump right into it. The first thing you need to know is as a 2-year conditional resident, right? You must you must file to remove the condition on your residency. This is not optional, it is a requirement. So if you do not file to remove the condition, then once your card expires, you no longer have proof of your residency. And then USCIS has the option to terminate your residency and put you in immigration court to basically get you deported. So when I say you need to file to remove the condition, it is not optional. It is something that you must do. Okay. So now that we know that you must file to remove the condition, if you only have a 2-year green card, let's talk about what happens when you're ready to file and your relationship falls apart, right? Because again, you're married to a US citizen, you got your green card through the US citizen, and now it's time to file to remove the conditions, and you're worried because either you two have already gotten divorced or you're not divorced yet, but your spouse is not willing to file with you, or you two have been separated, not divorced, but separated. So I'll be talking about the 3 ways. So there's 3 ways that you can still file an I-751 without your spouse. So these are the waivers, the I-751 waivers that you can use in order to still get your conditions removed and still be able to get your 10-year green card without your spouse that filed for you. The first way is divorce, right? So if you and your spouse get divorced and you have not removed the conditions yet, you are still able to, because one of the waivers is divorce. Now, you still you still have to prove that you and your spouse entered into your marriage in good faith, that you two built a life together or were in the process of building a life together. So you still have to provide documentation to prove your relationship. It doesn't mean that just because you two are divorced, you automatically get your I-751 approved. The divorce is only waiving the fact that your spouse is supposed to sign the forms with you. It doesn't waive the other requirements. So you still have to meet the other requirements of good faith marriage. Okay. So the way I explain this to people is basically you're saying that, we entered into this marriage in good faith. We plan to build a life together. It's just we realize that we don't work, right? The marriage doesn't work and we decided to get a divorce. And that's okay. All right. So that's what the divorce waiver is for. It's not for people that, once they got their green card, they skip town, right? If you did not maintain a relationship with your spouse, After you got your green card, the chances of you having your I-751 approved based on the waiver is slim. It is slim because USCIS is not just looking at, you know, oh, when you two met and all of that. They're looking from the time you got your green card to the time you're filing the I-751. What evidence can you give us to show that you and your spouse were in a real marital relationship? And that is where people usually mess up. So if you are not showing evidence of your relationship as part of your waiver, you are going to have an issue. Okay, you are going to have a hard time getting your I-751 approved. Now, what is actually proof of your relationship? That is documentation showing that you live together, right? Until you separated, divorced, all of that. Documentation showing that you two, had a joint bank account. It's okay if the bank account is closed down because you two are divorced, but that you actually had one, that you used it for your household expenses, that you two took trips together, that you two basically presented yourselves as a married couple to the world. This can be through Facebook. Social media is big, right? This can be text messages. All those things matter. Something else that people overlook is if there was ever a restraining order in your case, right? That typically is a negative, right? To most people, that's a negative. However, I have had officers that use the fact that there was a restraining order. The restraining order clearly is you and this person saying, this was my spouse. We are no longer together. I do not want them in my space anymore. Right. But you're still presenting yourselves as a married couple. You're still presenting yourselves as people that lived together. So things like that, even though it's not a good thing to have a restraining order against you, but that is one of the things we have used in the past to get these things approved, even with a divorce. Okay. So, what do you use to prove that you're divorced? Your divorce certificate. Okay. Um, if you are still in the process of filing for divorce, can you file your I-751? Yes, but just know USCIS is not going to approve it without that final divorce decree. Okay? Now, the next thing is when there is no divorce, right? If you and your spouse entered into your marriage in good faith, there's no divorce, so you can't use the divorce waiver. However, during your marriage, your spouse abused you, and now you two are separated, or they're refusing to sign the paperwork. Can you still file an I-751? And the answer to that is, of course, yes. Right? There is provisions made for victims of abuse, especially spouses of U.S. citizens and permanent residents that have been abused by their U.S. citizen or permanent resident spouse. So in those situations, you will need to, again, document your good faith marriage, because that is just a requirement that is not waived. It does not matter um, what the reason your spouse is not signing the forms are. The good faith marriage part is never waived. You will always need to show that your marriage was entered into in good faith. However, your spouse is not signing the forms because of the waiver, whatever the reason for the waiver is. So, good faith marriage is always a requirement. So always make sure that you have those documentations for good faith marriage. Now, for the abuse waiver, you still need to document the abuse. As I always say here, abuse can take many forms. Okay, physical abuse is the most known, talked about types of abuse. However, there are other types of abuse that does not result in physical violence. Okay, so do not, you know, diagnose yourself, basically. If you think you have been abused in your relationship, definitely seek therapy. Definitely talk to an immigration lawyer before filing an I-751 based on an abuse waiver, because um, you do have to show that you were abused in your relationship before you're able to file. So physical abuse is the most obvious, um, because sometimes, actually most of the times, there's proof of the physical abuse. Either someone called the police, someone went to the hospital, there may be police reports, medical records, court records. So we've had individuals where the spouse was charged with assault, and we have those court records and are able to present it to USCIS as proof of the abuse, right? Because typically a police report or court records will say exactly the reason that the person is being charged, who the victim is, um, and the spouse being the victim leads to evidence of an abuse taking place. Okay. Psychological abuse, financial abuse, those things are, they may be harder to document. However, it's not impossible. So, text messages, right? Threatening text messages, even psychological evaluation. So, that's why I say, talk to your therapist, really open up to them about what you're going through, and they're able to um, really document the types of abuse that you have been through and how it stems from your marriage, right? So those are ways to document abuse. Of course, your statement of what has happened to you, right? So it's not just about um, text messages and all of that, but you being able to basically document in writing everything that you have went through in your marriage, that you consider to be abuse. Maybe one thing, right? One incident where your spouse, says something negative to you may not be enough for a USCIS officer, but when you can show a pattern of behavior that just builds up over time, that may be enough for the officer. So, a single incident of physical abuse most of the time would be enough. However, sometimes a single incident of verbal abuse may not be enough. So it's just, again, that's why you do not self diagnose and decide that, oh, wait, this is not enough for an abuse waiver. You should be talking to an immigration lawyer before you make those decisions. Or sometimes you think that this is enough, but it actually isn't. So those are things to keep in mind. What can you do? This is another question, right? What can you do if you weren't abused, right? Or at least you don't think that it's at a level that USCIS is going to approve your I-751, but you're still not divorced yet. And you are literally about to miss your 2-year deadline to apply. Well, well, the 2-year deadline does not apply to you if you are filing based on a waiver. So typically, if you're filing an I-751 with your spouse, you have to file before your 2-year card expires. But if you are filing based on a waiver, for example, divorce or abuse, that 2-year deadline does not apply to you. So sometimes it may be worth it to you to file for divorce and wait for the divorce to be final before filing your I-751, right? So just because you have not, just because you have not gotten your divorce finalized does not mean you go and file the I-751 because you're afraid to miss the deadline. The deadline does not apply to you. Okay. If you are filing based on a waiver, the deadline does not apply to you. You can literally apply for an I-751 waiver at any time. So just keep that in mind. Um, and then, as always, there is the extreme hardship waiver. So like I talked about, there's the divorce waiver, the abuse waiver, and finally the extreme hardship waiver. So this is basically saying my spouse is not filing is not willing to sign the forms. We're not divorced. We're not, I did not suffer abuse in the marriage. However, if you do not approve this I-751, I will suffer extreme hardship. This needs to be documented, right? Extreme hardship is one of those things that, like, the officer really gets to decide if this is extreme enough for them or not. So it's, what is it that you have in the US that if you were to leave, that your life will completely change, right? Extreme hardship is, again, extreme hardship, not just that, oh well, if I'm sent, if I had to leave the US, I'll go back to my life, back home where I can get any job I want, live any lifestyle I want, right? That's not an extreme hardship. Now, if you have a medical condition that you're required to stay in the US, or that you're not able to get medical treatment in your home country, and you can document that, that can rise to the level of extreme hardship. So, for example, if you have children in the US, that if you were to leave, you cannot take them with you because their other parents are US citizen or permanent resident and are not going to allow you to take your children with you. Or even if they did allow you to take your children with you, your children may have medical conditions, they may need special education, and your home country is not going to provide that um, for them. So having the ability to stay in the US is best for you and best for your children, and you would suffer extreme hardship if they were not here. So those are just quick examples, but again, just like the abuse waiver, maybe one thing on its own may not be enough to be extreme, but if you have multiple things that go together, that you can use to then cumulatively show extreme hardship. Okay, so those are the three waivers for the I-751 removal of conditions. The first one is divorce, the second one is abuse, and the third one is extreme hardship. Okay, remember, with all these waivers, right? All these waivers, you must still prove that your relationship was real, right? Your marriage was entered into in good faith. You two planned on building a life together. It just didn't work out, right? Either it didn't work out because you two ended up divorcing, or because of your spouse abusing you, or for another reason altogether. However, right? However, you would suffer extreme hardship if this form is not approved. So those are the waivers. And another thing to keep in mind is, if you missed the 2-year deadline, please do not think that you cannot still file based on the waiver. You still can. So even if the 2-year deadline has passed, you can still file, because guess what? The 2-year deadline does not apply to you if you are filing based on a waiver. However, you must file an I-751. Okay. So if it's been a year since your 2-year card expired and you're like, oh, but we're divorced and, I can file, go and file, because the 2-year deadline does not apply to you if you are filing based on a waiver. However, if you're filing jointly with your spouse, you should file within the 2-year deadline, unless you have a really good reason for not filing within the 2-year deadline. Okay. So that is that. If you have questions, as always, please go ahead and put it in the comments. I really want to make sure that this is helpful to you as we are building our community and making sure that you are informed. So let's go to the comments. If someone has um, had petitioned for you, but stop at affidavit of support, he didn't send in everything, USCIS keep asking, should I assume that I have also applied for a green card? I am overseas. So if hmm, if there's an affidavit of support that is required, then most of the time that is because that someone is filing for you to get a green card, right? So even though you're overseas, you will get a visa to come into the US. And then once you get into the US, you will then be a permanent resident of the United States. So that will be the green card. So you don't really get the green card until you enter the US with the immigrant visa. If the affidavit of support is not filed by the petitioner, you would not be able to get the visa. So that is a requirement that USCIS and the embassy has. So the affidavit of support must be filed by the petitioner. If their income is not enough, they can get a joint sponsor, but the person that's petitioning for you must file an affidavit of support. Okay. If you all have any questions, feel free to put them in the comments. If you're watching this on the replay, hey, go ahead and put your questions in the comments as well. I do go back and respond to all of those. And that is all I have for you today. Thank you so much for joining me. As always, we are here every Friday talking all things US immigration, helping you know how to get a green card, citizenship for yourself, for your family, using the US immigration law system. I am Lillian Chukura, and I am a US immigration lawyer, and I help my clients get green cards and citizenships. If you found this video helpful, please feel free to subscribe, like, share, all the good stuff. And if you would like to know if you qualify for an I-751 waiver, please schedule a strategy session with me by going to my website, lilylegal.com, or by calling my office at 508-443-1788. Once again, thank you so much for joining me. I truly appreciate it, and I'll see you all next week for more immigration chat. Bye.